Hello, everyone. Welcome back to the Elated Real Estate channel. Thank you so much for joining. So many of you have subscribed and are sharing our information. We're so grateful for that. We're glad you've come back. This is part two of the earnest money topic. I'm going to go over the second part and really get a little more granular about earnest money and the topic related to that. So let's get started with the earnest money topic in general. As you remember, last time we talked about some of the key points of earnest money, and just to kind of recap that real quick, it's we talked about what it's for. So if you want what we discussed in these, please go back to part one. You're welcome to do that and come back to this video, or just listen to this one and go back to that one. They're both perfectly fine in any order. We talked about how much it should be, who holds it, when it's dispersed, when it's at risk, and how we can protect it. And we went over this particular part of the form, but today we're going to go into the more granular details found in the earnest money section of the Georgia Association of Realtors contract, where it talks about who's entitled to it, how it's dispersed, what to do when there's a problem or a dispute about who's entitled to it. And then it talks about the brokers hold harmless clause in the contract as well. So let's go over that. Feel free to reach out about additional questions you may have about what I'd go over today. And you can email me at jim.fountain@metrobrokers.com. You're welcome to reach out anytime. I hope you will if you have questions or if something's not clear about what I go over. But Section 7A of the Georgia Association of Realtors contract says that, subject to the paragraph below, the buyer shall be entitled to the earnest money in one of four ways. And so number one is if we don't come to a binding agreement. So there's no agreement met, then the earnest money is just returned to the buyer. A lot of times you'll have it where the buyer doesn't even make the earnest money deposit until the binding agreement's made, and some point thereafter sometimes. But if we don't come to an agreement, of course, there's no earnest money at risk. Number two would be that if there was a contingency that wasn't met, the buyer would be to return the earnest money, like due diligence or a financing contingency or any other contingency in the contract. Maybe your agreement is subject to an additional radon inspection or some other inspection or some other contingency. All of that would require the earnest money to go back to the buyer. If the contract, number three, would be if the contract is terminated through default of the seller. So if the seller can't hold their obligations, whether it's title issues or if they change their mind, then the earnest money would then go back to the seller. Or if the agreement's terminated, that's number four, the earnest money would go back to the buyer unless there's a termination of the agreement that's not within the specific right of the contract. So in other words, if there's a dispute, we'll go into that a little bit more. There would be a different way. But if it's an agreement that's mutually terminated, then the buyer would get the earnest money back, unless there's some other dispute about it. So otherwise, it'll be applied to the purchase price is what it says. And then the other funds that are needed, you could also use it as credit toward closing costs or other costs associated with the closing. So number B, or sorry, 7B talks about disbursement. So the holder, which we talked about last time, could be the buyer's broker, the seller's broker, the closing attorney, some other third-party attorney or otherwise, or it could even be the seller. The holder shall disperse the earnest money, it says, at the closing, in a subsequent written agreement from the buyer or the seller. So a lot of times that could be the buyer or seller says, the earnest money would go back to the buyer because some other reason the contract wasn't met. Number three is if there's a dispute, an order of a court or arbitrator that has jurisdiction over the dispute involving the earnest money could make a court order, or an arbitration could make an order to give the earnest money to one party or the other. And then if the contract doesn't come to a consummated contract, so if we don't go to a binding agreement, the earnest money would be dispersed in accordance to the way that it's outlined in the contract. So then the holder may disperse the earnest money upon a reasonable interpretation of the agreement. When I'm representing a buyer or seller, it's important that the holder of the earnest money is going to be reasonable, that's favoring, a reasonable interpretation of the agreement. So there's some process that they have to go through, and that's outlined here. We'll go more into that. We'll do a video about earnest money disputes. But they have a 10-day notice they have to give about why the disbursement will be made, and then they can go through the process of making an objection to that determination. And if they don't do that, then they will be deemed to have waived that right. So if they receive an objection during that period, the holder of the earnest money has to send notice to all the parties of the holder's determined actions. So there's a lot that goes into this. We'll probably do a whole new video about this because there's a lot of different scenarios that can come up out of this. But they may disperse the earnest money to the seller or the buyer by check after a reasonable interpretation has been made. And then after that 10-day notice that we talked about, and then that check shall constitute liquidated damages to the seller against the buyer. And of course, the brokers have agreed to be held harmless in this. So there's a lot of other process that's outlined in the section 7B. And you can read it here in the lower section of that paragraph. It says, the holder may require the seller to sign a W-9 before issuing a check for damages over $600. The liquidated damages are a reasonable pre-estimate of the seller's actual damages. So they're saying that the seller couldn't go and sue the buyer for more than the earnest money. And that's why it's important to get enough earnest money to cover what you might consider to be damages if you're a seller selling your property. Section 7C talks about the interpleader. If an earnest money dispute can't be resolved, it says, after a reasonable time, the holder may interplead the earnest money into a court of competent jurisdiction. So in other words, if we're selling real estate in Fulton, DeKalb, or Cobb, as an example, they would put that earnest money into a competent jurisdiction where the earnest money could be resolved through a court process. So the holder of the earnest money, the real bottom line here is the holder of the earnest money doesn't want to get into a dispute while the other parties are the real parties having the disputes. They don't want to be involved in that. So anyways, the prevailing defendant of that earnest money, the interpleader lawsuit may be entitled to collect attorney fees, court costs, and any other amount deducted by the holder to cover the holder's costs and expenses. So in other words, the holder of the earnest money wouldn't incur expenses because they've agreed to hold the earnest money, is what that's saying. So it's not like if the brokerage is holding earnest money, they're not going to all of a sudden be responsible for the expenses related to that role in the transaction. And then the last section, 7D, just simply says that the brokers will be held harmless. So no lawsuits would be filed against the brokers related to, or the closing attorney, or the seller, or the buyer related to the way that the earnest money is held, so long as the letter of the contract is followed. So this is a little bit of a deep dive on the earnest money process. Generally speaking, what we covered last time is that, the earnest money would be credited back to the buyer at closing toward their down payment or closing costs. And the seller would use that money it's used to show intent, with the intention to purchase and good faith in that regard. So hopefully this has been helpful. This is a deeper dive on this topic. It's a little more advanced look at the earnest money side of the real estate transaction. I hope it's been helpful. As I said in the beginning, if you have questions or specific questions about your scenario or some other scenario, questions you have about that, please reach out to jim.fountain@metrobrokers.com. Happy to try to talk through what your situation might be. Hope you've enjoyed it. I hope you've already subscribed. I hope you're sharing our channel and enjoying it. And if you have future ideas for topics, please reach out to us as well. Hope you're doing great and hope to see you again soon.